Welcome back to HR Shake, a podcast where we bring people, work and passion into the mix. I'm your host Camelia, and today we are going all the way legal. We will have a very interesting topic, and that will be labor law. And we will find out what it actually entails in Luxembourg, what companies should actually take into account when working closely with their employees, and maybe some tips and tricks. Let's find out. And today I have a very lovely guest, Eric Weber, who is a labor law lawyer at Stellan Partners. Welcome, Eric.
Hello, Camelia.
Thank you so much for coming today.
Thanks for having me.
And before we jump into the topics, I was really curious to hear from you about your activity and what is it that you're doing exactly.
I'm an employment law lawyer at the law firm called Stellan Partners. So Stellan Partners is a Luxembourg-based law firm, and we cover a wide range of areas, being it corporate law, M&A, banking capital markets, investment funds, family offices, private equity, real estate, data protection, and employment law. And the team of which I'm part of, the employment law team. So we advise employers on being it through the cycle of the employment relationship, so the drafting of the employment contract, modifications during the employment relationship, big determination, dismissals, settlement agreements, also representation in court, interactions with the staff delegations related to policies like moral harassment policy, teleworking policy, right to disconnect, whistleblowing policy. Then we also are into social security aspects, pension, immigration for employees that come to work to Luxembourg, third country nationals, remuneration policies, and also business license. So we try to cover pretty much all aspects that are related for employers in employment law in Luxembourg.
Sounds quite complex.
It is from time to time, but we love it. We are passionate about it. So
I think that's the most important thing.
Exactly.
And which part is your favorite?
Oh, that's a difficult question, but I think it's like the mix that makes it, and the human aspect and part you have. You're going to contracts, you're advising clients, you're also going to court, so you have the mixture of all the good ingredients.
You have the action, you're right in the middle of the action.
I love the action.
That's really good. Perfect. And since we are talking today about labor law, I would be very curious to cover some of the myths that I keep hearing about in Luxembourg. And one of them, of course, is about pay transparency. As you know, there is a pay transparency law that is coming into place now in June. And according to some people who have, let's say, heard a little bit about this law, it's just, about publishing salary ranges. Is that true?
No, totally. I think it's more than this. It goes way behind this. Indeed, for pay transparency, there's a European directive from 2023 which needs to be implemented into Luxembourg law within 3 years, so for 7th June 2026. This is longer than usual because normally a directive needs to be implemented within 2 years. Here we have 3 years, so it shows already the complexity. In Luxembourg, as of today, on 11 March 2026, we do not yet have a bill of law. But in general, the Luxembourg legislators tend to have a law that is very close to the text of the European directive. So what is this directive about? It's about to close the gender pay gap. Gender pay gap, what is it? Well, it's basically the average hourly salary a woman receives in a given country compared to the average hourly salary a man receives in a given country. And in the European Union, for instance, we have a gender pay gap of around 11%. In total, means that a man receives on average per hour 11% more than a woman. Here, Luxembourg is best in class. We have minus 0.8%. Women earn actually more.
Yes, that's very true.
But it also depends a bit on the sectors. For instance, for the finance and insurance sector, we have around 18.6% gap for men. So there's also, depends on the sectors where you're at, where still are some differences.
Interesting. And speaking of this, if a company has never formalized these grading structures, how exposed would it be once this law comes into place?
Well, actually, indeed, every company needs to categorize the employee to put them in certain categories for employees that do equal work or work of equal value. So to give you an illustration, for instance, if you have a bookshelf, a library, and you have a lot of books lying in total chaos on the floor, and you have to put them into the bookshelf. But first of all, you have to categorize your bookshelf, your library, in different categories. So this kind of book, this kind of books, and after all the books have to fit in this bookshelf. So you can't have like a miscellaneous category you put everything in notes. You need to categorize this very thoughtfully and to have a place for every book. And this is what is complicated about this job.
Yep.
And this obligation applies to all companies independently of size. Some companies may be subject to a collective bargaining agreement where you have some categories that can give you inspiration, but that's not necessarily enough and does not apply to higher ranking employees. And why is it also important? Because an employee may request under the text of the directive his employer to provide him for his category the average pay for women and average pay for men. And this is able to enforce his rights for equal pay. And if there's difference, does not necessarily mean that it's discrimination. It can be explained on the basis of skills, for instance, or responsibility could be a possibility.
So if the companies don't manage to do this type of categorization, as you said, then they would be subject to fines or...
There are certain fines that already are in Luxembourg law. There will also be fines that are coming from the directive, and I think there are different types, but what's important also is that as a shift of the burden of proof, if the company does not provide the information, it has to prove that there is no discrimination. It will no longer be the employee who has to prove that there is a discrimination, it's the employer who has to prove there's no discrimination. So this is actually harder for an employer.
Understood. Okay, got it. Well, thank you so much for giving that details, because I know it's a quite important law and not many companies are prepared for it. So hopefully you are. Otherwise, you heard what will happen. So preferably do do your homework.
It is indeed a very hot topic, and there are also very many other obligations. We also have the objective and gender-neutral criteria that need to be determined. You need to determine these criteria on the basis of skills, of responsibility, of effort, be it mental or physical, working conditions, not sex. So this is also an obligation. There are also many. I think this is a high-level summary of some objects, but should deep dive and really take into consideration this directive, because it's coming fast and obligations will apply quickly.
Stay tuned and watch out. Okay, so going on now to the next myth. Speaking of labor law in general, I know that you have this idea, or companies have in general this idea that if we're generally compliant, we just need help when something goes wrong. They don't have to follow all of the rule sets. How true is that?
Not totally true. It's also good to have prevention.
Good to have prevention. So what do you think are the most common, let's say, preventable mistakes you see in the Luxembourgish companies or the Luxembourg companies?
I think there are, in general, employers are very well prepared and know a lot of employment law. One could be not being prepared for pay transparency directive, but apart from this, I think we have elements with regard to deadlines sometimes that, for instance, if you dismiss someone for gross misconduct, you can dismiss for gross misconduct or for notice. Gross misconduct is with immediate effect for a very severe aspect. Then we need always to comply with the 1 month deadline, because afterwards we will no longer able to dismiss for this gross misconduct. And it's not always that easy, because sometimes you have like a suspicion, but you're not really sure. You need to investigate. So this is always important to keep these deadlines in line, because it's sometimes very procedural. You also, for instance, if an employer dismisses with notice, the employee has 1 month to ask for the reasons. The employer has 1 month to answer. What we also often see with, or sometimes with deadlines, is that in case you have a trial period, then the notice period needs to be set within the trial period. So for instance, if you have a 6 month trial period, you have 24 days of notice, and the notice needs to run at the latest at the end of the 6 month trial period. Otherwise, you're outside of this trial period. True,
and if you don't give the feedback at the end, you lost it. I mean, the person automatically passes the trial period, so they have to be very prepared.
Yeah. And that's also a good point that you're talking about feedback. What we also often see, or sometimes, is that feedback is given orally. This can be cultural of the company. It can be that the employer doesn't want to be too rude, or maybe the employer doesn't have time, the manager, maybe the line manager says this and this is not good, but he will not now take the time to draft an email, etc.
That's true.
The problem is then sometimes an employer wants to dismiss for underperformance, but he hasn't documented enough and then there's a lack of proof sometimes coming. And although maybe the employer knows how it is, the employee knows how it is, but the problem is that we do not have the proof. And maybe a last element around this, which we also sometimes see, is consistency. If an employee successfully gets the trial period, so it's not dismissed, and then 2 months afterwards an employer wants to dismiss, there might be a risk that a judge says, there might be inconsistency. You said that the trial period is validated, but now afterwards you want to dismiss him. Or if an employee gets like a huge bonus, but is also said that he has performance issues, maybe set on a performance improvement plan. So this will also need to be consistency.
How often do you see these type of issues, especially with, let's say, with dismissing people on performance situations, on issues?
It happens sometimes because maybe that the bonus is maybe determined by the group, or maybe it's kind of motivation, and then we still give a bonus. But at the end of the day, it's still could be considered as inconsistency. It happens, but it's not that often either.
Understood. And speaking of performance plan and performance issues, we are just going to jump on the next myth because you just brought it up. And there is this another myth that I heard actually in one place saying that if we put the employee on a performance improvement plan, we're legally protected. True or false?
That's not totally true either, because that depends on how the performance improvement plan is drafted, concluded, so there are many elements to consider.
Okay, so then what should employees and employers have in mind when they go through such type of legal, let's say, procedures when it comes to this performance improvement plan, dismissals when it comes to performance improvement plan, and so on?
So the performance improvement plan actually, for the context, is when an employer is not entirely happy with the performance of an employee, he might have a possibility to say, we have a performance improvement plan, also known as PIP, and as the name indicates, well, it's a document in general indicating and outlining how the employee should improve compared to the expectations of the employer. So what is important, I think, first of all, it should be in writing. We need to have a trace of it, and everything is clearly determined. Then we need to have clear objectives. Ideally, they are measurable, so we have a certain degree or whatever to reach. They should be realistic. This is an interest also of both parties, because if the employer wants to dismiss afterwards, but the objectives were not realistic, or if for the employee who cannot reach the objectives because they were not realistic, it should also indicate the means on how the employee should reach these targets. There should be timelines on the one hand, progress, maybe progressively made. There should be also timelines on feedbacks given, on check-ins with the line manager, or maybe other persons. Also, should everything be fairly documented for both parties. I think the employee should be active also about this, raise questions if something is not clear, maybe say, can I have a training on this? It should be really a conversation. So be proactive, basically. Exactly. It's also definitely in his interest. And it should ideally be signed by both parties, that they also say that they're in agreement with the terms on this, if they are then. And also why I think this is also all important, because the performance improvement plan is often a crucial point in the employment relationship, because I would say there are basically 4 outcomes of a performance improvement plan. The first one would be the employer says, well, very well, you did what we expected, what we agreed on, performance improvement plan is over, let's continue our working relationship. The second one would be the employer says, this isn't what I expected, I think we're not going to get there, and might dismiss the employee. The third possibility would be the employee to resign. You might get frustrated, or might say, I will have better chances elsewhere, and leave the company. And the fourth one would be to extend the performance improvement plan, and then at the end of this extension, we probably get back to the solutions 1 to 3.
I think it would be very demotivating if you extend it to the fourth one, because, I mean, if the person goes, let's say, it prolongs their suffering, it will not help with the, let's say, the overall improvement.
It can also be that this extension can also be a bit different. It can also be that there are like improvements in the work rate, but the employer might say we need to get a bit more, and then we are getting there. That can also be an option. So it is not necessarily a negative.
Okay, understood. Well, in Luxembourg, to be honest, I do have the sense that it's perceived quite negatively, given to some particular situations in some companies where it has not been a very nicely, let's say, implemented. So therefore, when you are an employee and you hear about performance improvement plan, you do panic because you think of the worst case scenario, which is, I totally relate, because I understand that it's not the best. Yeah. So in this case, basically, you kind of, okay, you've given us the idea of what they should have in mind. Is there anything maybe in terms of tips and tricks for employees in particular when it comes to dealing with this type of situation, if you have, or if it's okay if not?
I think it's the elements we said, and employees should be proactive. I think that's very important. Not just maybe sign, but also ask questions, get involved, and show that they really want this, and to go back on the track that both parties are happy with.
And can they choose not to sign if they don't want to?
They could choose, but ideally you have a performance improvement plan that is agreed by both parties. That's the best you could have, yeah. Understood.
Okay, perfect. Thank you for giving this insights. And there's a last myth that I wanted to cover here, and that's about harassment. We all know, and probably we've all been in that, let's say, environment in a company where either if it was moral harassment or other type of harassment, hopefully not, and some consider it as, it's just pressure, it's normal in business. Is it?
It should not be normal. Moral harassment, there's a law of 2023 which also obliges an employer to take action to prevent any moral harassment, and ideally, obviously, there should not be any moral harassment in a company.
Top, perfect. I'm so happy that we're on the same page. And how does what would this actually mean for an employer, this type of this moral harassment, or this harassment law?
Well, maybe the employer will need to, like I said, put some preventive measures into place. So generally, this is done by the way of a moral harassment policy, so a policy that sets out some elements. On a high level, what will we need to include, or what should be included? Also, what the law says is that the way a victim can report on moral harassment. So be it, for instance, an email address, be it a telephone number reporting to this and this person, could be the head of HR, the head of the company. Then how will we accompany the victims, have some measures, maybe some timelines, some preventive measures also. Then there should be a rapid and impartial investigation. The employer will also have to sensitize his employees and also the manager about the definition of moral harassment, what it means. Then the employer will also have to train his employees. This can be done internally or externally. We, for instance, did an e-learning program together with PwC Academy, so for clients that can provide this to their employees, where they will have like a training on the definition and all the important elements of moral harassment.
And I know they have to have also a committee, if I'm not wrong, that does the investigation for the moral harassment, because it cannot be the manager who, for example, is involved in the
exactly
in the procedure.
Exactly. So for the investigation, you need to determine the persons, and that's also the criteria: the rapid and impartial. So rapid meaning rapid. There is no specific deadline, but it needs to be depends on the complexity also of the case. And impartial is that the persons involved will need generally this the head of the HR or head of the company. So obviously the person can also not be the one that are subject to a potential harassment. And this is in line with the investigation. Only need to ask the victim, but also the potential harasser, to ask any witnesses that might be there, so to have a complete investigation. That's an obligation the employer definitely has. Understood.
And we've talked about moral harassment, but we haven't mentioned exactly how the Luxembourgish law defines it. How would someone identify this?
So the Luxembourg law, the labor code, defines it as Luxembourg labor code defines moral harassment as any conduct which by its systematization or repetition undermines the dignity or the physical or psychological integrity of a person. So what does it mean? We need to have a conduct, first of all. That can be an action or not doing something. It can be written, or it can be verbal, it can be mockeries, that can be isolation, can be constant interruptions, there are many instances, but it needs also to be assessed on a case-by-case basis, depends. Then we need a repetition, so it's not only one act. In principle, we need at least twice, so 2 acts at least, so it constitutes moral harassment. So we need also to have this, that it undermines the dignity or the psychological or physical integrity of a person. It's always a question of the intent. In general, we need an intent to have it, but it's not necessarily the case. Maybe also the definition, the scope. It's not only the employees, it's also the apprentices, tutors, students, etc., but also the suppliers and the customers of the employer are in the scope, and the scope goes also way beyond the normal. It goes to the context of the employment relationship, so meaning business trips, trainings can also be exchanged outside of the working relationship. So it goes quite wide. I think what also we can say, what is not moral harassment, well, generally the normal stress you have at work, you always have stress at work. The authority of the employer within legal boundaries, he can give you orders, he can check your work, he can sanction an employee, and that is also within legal boundaries totally normal.
As long as it doesn't impact the integrity of the person, or it doesn't scream, or if I understand correctly, it doesn't offend the person, then it should be within the normal, let's say, activity, the day-to-day life of a working person, correct?
It's exactly, it's in the case-by-case basis, but it's normal that an employer gives orders and tells an employee what to do. It's link of subordination.
Understood. And once, let's say, we have the situation in a company where something happens, we have moral harassment. In this case, probably happening twice in order to consider that it was moral harassment. What must an employer do once they are aware of this?
Like what employer will need to stop any acts of moral harassment that might be and take preventive measures, maybe also just temporarily during the investigation, and then needs to do the investigation we just talked about, which needs to be rapid and impartial. At the end of this investigation, there are 2 outcomes. Either the employer concludes that there has been a moral harassment, so we'll have to inform the victim about the conclusions of this investigation, and then take appropriate measures with regard to the person that has been the harasser. Then this can have different degrees. In practice, often ends with a dismissal, be it on from notice or even with immediate effect. And then he has also to take maybe appropriate measures to the victim, maybe psychological support, check how she can continue and go on. Then there's also the other option. The employer will conclude that there is no moral harassment. He will also have to inform the victim of that. And the conclusion, what's important, there cannot be any retaliatory measures against the person. We reported this. There's just one exception if there has been a report made in bad faith, for instance, to harm another person within the company. And then he also should check what measures he can take with this person, which this subjectively considers on being harassed. And last but not least, the employer is also to check and reassess the measures that are in place, considering this incident that happened, if this everything is, grosso modo, if everything is all right.
Understood. That's an interesting topic, and well, it's not a very pleasant one. And hopefully, hopefully we won't have many cases of moral harassment here in Luxembourg. Although I did hear about a few, but hopefully they will not multiply, because it's never a good thing, to have this type of situations at work for neither of the 2 parties. But in any case, thank you so much for giving your insights today.
Thank you for having me.
About labor law. It's a really interesting topic and very, very vast. I think if we started speaking about it, we will never finish.
Yes.
And you've watched another episode today of HR Shake, a podcast where we bring people and myths into the mix. Thank you so much for watching, and stay tuned for our next episode once it launches. And until then, follow us on LinkedIn and on YouTube.